You're listening to The Rule of Law, the educational podcast sponsored by Allrise, where we focus on the intersection of law, technology, and storytelling. And now, here's your host, Lauren Round.
Do you have a proactive ethics program in place for your practice? If not, your firm is a bar complaint waiting to happen. In today's episode, David Michael takes us through the ins and outs of PMBR, Proactive Management-Based Regulation. We cover how to set up a proactive ethics program in your law firm, how states are adopting PMBR, and how being proactive can help you if you do find yourself on the wrong end of a bar complaint. David, welcome to the show. Where are you recording from?
I'm in Milwaukee, Wisconsin right now, and I'm on the 16th floor of an apartment complex. And guess what? Today they are washing the windows. And so I'm certain that during this recording, the window guy is going to come right down in front of me and be washing the windows. So I'll let you know when that happens.
I'm sure. Okay, if we see him in the window, we'll give a narration for our audio only audience. But yeah, Murphy's Law, I'm sure they will come in this 1 hour slot that we have.
That's just how it works. Yeah.
Yeah, exactly. And I think actually now that I think about it, I think you're our first guest from the Midwest, which is really special to me because I'm from Minnesota. But does that mean you're a Packers fan, or what's your sports team?
Well, we probably shouldn't spend a lot of time on sports, but yes, I'm not a shareholder, but I am a season ticket holder for the Packers and a big fan. And I go, even in the wintertime, I go to the games. So that's important to me. I'm also, just a crazy cheesehead about everything Wisconsin. I love it here. And the Midwest is a wonderful place, even when it's 100 degrees, which it was like yesterday. The heat index was very high. So.
Yeah, absolutely. I miss it. I know people don't understand that the Midwest gets really hot too. They think it's always just cold all the time. But yeah, some hot summers for sure.
Right.
Well, we always start the show with an icebreaker to kick things off. And you are a tech software guy, so this is for you. The question is, what is one app that you would not want to live without?
One app that I would not want to live without. Probably the weather app. I have to know what's going on outside, and particularly in Wisconsin, because we don't get that many really nice days. If it's a nice day, I'm outside. And so we spend a lot of time watching the weather. Of course, we've had hail and crazy weather. Just had a tornado about 10 miles from my house yesterday. So the weather app is probably the thing I'm pay more attention to than any other app on my phone.
Okay. Yeah, I'm the same way. And it feels like not that long ago that we had to rely on news and wait for the local forecaster to come around and give kind of the week and the 10-day forecast. But now it's just so much easier. But it wasn't that long ago that we lived without the weather app. So.
Right.
All right. Well, thank you for that. Before we dive into some of the content we have today, if you wouldn't mind getting us started by just giving us a little bit about your background and tell us about your journey to legal consulting.
Great. Glad to do that again. My name is David Michael. I'm a member of the Crosspoint Consulting Group, and we're a team of independent consultants from around the country who come together and help law firms implement software. I started off actually at the University of Wisconsin. I have a master's degree in public administration, and I studied judicial administration. I designed databases for the court system and eventually became a trial court administrator, where I got to implement some of the very software that I had designed and implemented in previous capacities. And so that was many years ago. And now I have been doing software for law firms and legal agencies for about 25 years. And really have enjoyed that. I'm nationwide. I'm in 47 different states. I have clients right now, and it keeps me plenty busy. But today's lawyers and legal agencies are much better at software than they used to be. And back in the day, we had to teach them how to do everything. And nowadays, a lot of stuff is plug and play, and people are ready to move forward very quickly in this industry. So it's a very changing environment, and it's a very exciting place to be working.
Absolutely. Yeah, and that actually parlays perfectly into what I want to get into today, which is how you work with law firms on risk and particularly ethical risk. Because, like you said, law firms are moving faster than ever and implementing new software and not just that, experimenting with different marketing and hiring and all of these things. And I think a lot of us learn about ethics rules mostly in law school and some of the regulatory risk that comes along with running a law firm. And maybe we, refresh a couple times in CLEs here and there. But my impression is a lot of lawyers, we just do our best to avoid ethics violations. And that is basically the strategy. Just do your best. But there's a different approach that I've been hearing about. And one of the reasons we wanted to have you on to talk about that seems to be gaining some traction is this PMBR concept. So, can you explain to the audience, just at a high level, what is PMBR?
Great. Well, just by description of what it's not, currently, if you have a client who thinks that you have violated the code of conduct, they file a complaint with the Bar Association, and then the Bar Association has to do due diligence and investigate whether or not what they're saying actually constitutes a violation of ethics, and then what to do about it. The new model is called proactive management-based regulation. And this actually shifts the responsibility to assess whether or not you're doing things correctly back to the firm. So rather than a reactive model, which relies upon complaints filed by the public who, frankly, don't often understand the actual nature of ethics, they'll complain, oh, I lost my case. He did a bad job. That must have been an ethical violation. That's the most common complaint, of course. But we have to educate them about what an ethical violation is. Well, rather than do that, we're educating the Bar Association, through the Bar Association, lawyers and law firms, what good business practices are and the business practices that will keep you from getting a complaint in the first place. So that's PMBR, proactive. You do it ahead of time, management-based. It's not about case by case. It's about managing the process, and it's really self-regulation. You are the author of your own checklists. You're the author of your own procedures, and you're the author of your own remedies. And this is a much preferable model to having someone from the bar come in and tell you that you need to change and kind of force you into a new culture or into a new process. This way you get to invent something that works for you and for your culture and for your firm objectives and goals. So that's what PMBR is.
Yeah, and I think this is such an important concept for our listeners because we talk a lot about tech and AI. We've talked about fun things like marketing, but as one of my law professors said, friends and haste are the two things that are going to get you in trouble with the bar. So fun things like we talk about, like tech and marketing, are important, but there are also a lot of risks associated in just about anything you do in your firm. So I love the idea of being proactive, and I think that can be really effective, whether you end up in front of the bar eventually or not.
Right. And I think being proactive and having a system is also, well, not formally a mitigating factor against a complaint. It demonstrates good faith. And bad things happen. People get crosswise. This is normal. But if you have safeguards in your firm, you're doing things the right way, and you can show that to the bar, certainly that is taken into consideration. So good practices are not just preventative, but they're also remedial.
Yeah, for sure. And like anything, the state bars have their different approaches to how they investigate bar complaints, their rules. And the ABA, I think it was back in 2019, first recommended the adoption of PMBR programs. But since then, it seems like some of the states have sort of taken different approaches. So, how are states approaching this model, and how prevalent is this in the US?
Great question. Well, it may not sound like a lot to say only 8 states currently have formal PMBR programs, but it is also in Canada, Australia, New Zealand, and Europe, and the British Isles. PMBR is here, and it's coming on strong. Many states are on the roadmap to developing PMBR programs, but haven't really become very public with them until they get further along and have articulated what their actual processes might look like. Other states like Colorado, Hawaii, Illinois, Iowa, these states have become very active in PMBR, and they have published their self-assessment checklists. They have videos, they have manuals, they have all kinds of information, and they have different approaches too. So most of the time, PMBR is a voluntary thing. But in Illinois, if you do not want to have malpractice insurance, you have to do PMBR every 2 years. And the PMBR demonstrates that, well, I don't need malpractice insurance because look, I've got my act together, I'm doing things according to the rules, or I'm working in an area of law where there is no risk really of being litigated over malpractice. So, there's a variety of ways that PMBR is being implemented or will be implemented, but the process is prevalent, and people are doing this even absent regulatory enforcement. In other words, PMBR is something that helps firms do a better job, gives them a better handle on their firm and their procedures, looks good in the eyes of their clients, and has good results. Can lead to profitability, more staff retention, more staff attraction, better adoption of technology, and actually better sleep at night. When you know that you're doing things the way that they should be done, you can rest and not let it worry you all the time.
Right. Yeah. Back to what we started with. It's a much different model than just doing your best and hoping for the best and getting some of that peace of mind. So it seems like states are moving in this direction. One, because like you said, their interest is protecting the public, but there's another aspect, which is cost saving. It's really expensive for state bars to investigate complaints. They aren't always resourced appropriately. And so they have an incentive to have attorneys do some of this heavy lifting on their own instead of spending resources investigating. Can you talk a little bit about that and what the conversations are in the state bars when they're considering this?
Absolutely. Well, the first thing you should know is that every single complaint that's filed with a bar association will get due diligence, which means you can't just say, well, this one's illegible or incomprehensible, or, they're just complaining about the results and then just dismiss them. That might actually be the case for 90% of the complaints. But the bar associations, the bar council, they exercise due diligence with every single complaint. And that means a staff person is reading it, is reading between the lines, is looking for collaborative information, anything that will support actually the complaint. And they might recommend dismissal, but before they actually get the board to dismiss that action, they may also have to document other sources they went to see if their complaint had any probable cause of having violated the ethics rules. So if the bar association or bar council can decrease the number of complaints filed, it proportionally decreases the expense associated with researching every single one of the complaints that are filed. So this does save money for the bar so that they can put their efforts into other programs, they can put efforts into CLEs, they can put efforts into member services, and they can put efforts into public education instead of spending that time and money on so many complaints, which are often specious. So certainly this will save money for the bar. I think also it will save money for the firms. There is nothing more expensive than legal representation. And so if you have a complaint and it goes the distance in any way, you're going to want to hire a lawyer, and your firm is going to have to pay to represent you. And so this is not something people want to do. And so PMBR is going to decrease expenses for both the firm and for bar counsel.
Sure. It truly does seem like a win-win-win all the way around for sure.
Deploying new software technology can disrupt familiar workflows and processes, and it often comes with a steep learning curve for the employees in your law firm. We get it, but it doesn't have to be that way. Allrise is a comprehensive law practice management system deeply integrated with the Microsoft tools and technology you're already familiar with. So, no steep learning curve is required. And because Allrise is a modular software platform, you can deploy only the specific capabilities you need when you need them. Your choice. If you want to streamline internal operations, boost staff productivity, and deliver superior client service, then take a close look at the AI-powered Allrise platform. It's time to experience software innovation that enables practice excellence. Learn more at allrise.ai.
I mean, kind of help us conceptualize this. Like, what are some real world examples of PMBR? You mentioned in Illinois, you have to do something every 2 years. What is that? What does PMBR look like in the real world?
Okay. Well, the states that have this have web pages that you go to, and then you click to download their checklist. And so you'll fill in this checklist, and then you'll certify that you did it, and then you'll email it back to the bar and say, here's my documentation. Here's the checklist that I downloaded. Here are my responses. And that's compliance. That's actually doing it. Now, again, for most states, this is a voluntary process, doesn't get sent to anybody. You do this for your own sake and for the sake of your clients, and it's easy. So, for example, you can go to Hawaii, and Hawaii is a small state, but has a very good PMBR program. Every one of the areas of law or areas of process that PMBR has, there's usually about 10 areas. They just have this Word document that you can download, and it gives you a little preamble, and then it has a series of questions that you answer. Yes, no, maybe so. And then if it's inadequate, what are your own personal remedial steps? What are you going to do about this? And so you just fill out the form and then, save it, hopefully make changes, implement those changes, and then fill out the form again in a month or two and see if your answers are different. And you just work through this incremental approach to improving your workflow, improving your processes, improving confidentiality, improving client communication, making sure that your trust accounts can be three-way reconciled, doing records retention correctly, maintaining confidentiality, training your staff, all of the just typical areas of managing a law firm or managing any business, frankly, requires some attention to these details. And you do them all the time. You do the work. But in addition to doing the work, you need to look back and say, I'm doing it the right way. So here's a category, client communication and management. So it has 5 steps. It says, first, implement a system for regular client updates. What does that mean? Well, I was in a firm in South Carolina, and what they did is actually came in on a Saturday morning. They brought breakfast, and they had the staff sit down, and they went through their list of open cases, just the cases that were open. And they asked everybody, okay, what was supposed to happen in here next? When was the last time we contacted this client? Who's going to contact them next? And they assigned every case to somebody to respond to that client. That was a regular system of client updates once a month. Great system, aside from coming in on Saturday. Establish clear communication protocols. So, for example, if you get an email and you're in a law firm, what's the deal? Do you respond right away? Do they get an autoresponder? Do you let it sit for 24 hours? Do you respond within 48? What's the rule? You should have a rule, and it should be not enforced, but encouraged that everybody tries to apply the rule. And when it comes to communication, using engagement letters to define the scope of representation. Again, this is a formal process. You send this letter to your client and say, here's how I'm going to represent you. I'm going to do this and this and this, but I'm not also going to do your traffic ticket. I'm not also going to do your homeowners association issue. I'm going to address only this particular matter. That is my intention. And if you communicate that with your clients, then you're managing their expectations. And then they won't come back and say, yeah, but you didn't take care of my DWI. Right? Well, I told you I wasn't going to. You also need to maintain detailed records of all client communication. He said, she said, happens all the time, even in bar complaints. And if you have the audit trail of every time you replied to a customer and they say, oh, he's non-responsive. He made me wait 6 days to return a phone call. You can go back to your records and say, no, I returned that call 2 days later and I left a voicemail, at this date and time. So maintain detailed records. And then finally, the suggestion is to have a client feedback system. We should ask our public, our serving public, how are we doing? What might I have done better? And you can frame those questions in a way that talks about the process and not about the results. And this is an important distinction in law firms, right? A lot of the public want to talk about results. Well, did you win my case or not? But when it comes to business processes, it's not about winning. It's about, did I maintain communication? Did I maintain expectations? Did I do the right thing in the right way for you? And that's what we're trying to get at here, not necessarily the results. Now, hopefully all of these procedures together do result in better results for our clients. But one of the big things in the law firm community is like, you never promise your client results. Never, ever promise results. You can't do that. You can only promise good process and to represent them well. So I hope that was a good example for you.
Yeah, no, that is super helpful. And, as you're kind of running through the checklist of processes and procedures that lawyers and law firms should have, I mean, that seems like something every single law firm should be doing. It seems kind of like table stakes. And I think maybe even folks outside of the legal industry would be surprised that in a lot of states, you don't have to do any of that checklist before
Right.
you open a firm and start representing people. So, and I've often thought about this, the bars require attorneys to pass the bar exam, very specific questions, all areas of law, most of which they're never going to use. And then you can just go open a law firm without like really any cursory checks. Of course, you have to be barred and you have to pass if your state has, ethics requirements. But that checklist just doesn't exist in most states. And I think that's surprising to people. And hopefully PMBR catches on. And so we will have those checklists. I think that will be better for attorneys and clients going forward.
Yeah. And that's the goal, really, is to make things better for everybody and not have it be a punishment-based mindset. We're thinking, well, if I don't get caught, then I didn't do anything wrong. That doesn't lead to a good night's sleep. Knowing that you are adhering to the rules, that your staff is well trained, that you have processes in place that catch things that may otherwise slip through the cracks. This is what leads to a good business and a good law firm, and actually to better clients' satisfaction. So.
I also wanted to ask, we are a pretty technology forward podcast. And, as you know better than anyone, now there's more tech out there than ever for law firms to choose from. So how does tech kind of play into a PMBR framework if you're going to implement that as a firm? I mean, do you have practices around how the staff is supposed to use every piece of technology, the standards that technology has to have before it's implemented in the firm? I mean, what's kind of the crossover there?
That's a really great and frankly, a loaded question, right? There's so many ways that we can address the technology intersection with PMBR. The first one I think is important is this idea of knowledge management. So you can actually put into your practice management software the instructions on how to do something that stays within the lines, that gets the job done with the ethics in mind, as well as with the goals and culture of the firm that you want to reinforce. And so instead of just having a task that says, contact opposing counsel to determine their preference for a mediator, that's a pretty cut and dried thing to do. Well, you could embed in that cultural indicators of deference to opposing counsel, civility with opposing counsel, and also efficiencies, like saying, well, here are 3 days that we would like to have the mediation occur on, and here are our preferred mediators in case you'd like to choose one of them. And you can make all of these steps something that a paralegal can follow and check off the list as they go through. And so the technology itself can be knowledge management. Next, the technology actually can do things for you. So, for example, you can have a system where when a document is filed, it is automatically optical character recognized, right? It's OCR'd, so that makes it searchable. And then it's placed in the proper folder by the matter that it belongs to, and then it sends a notification to the responsible attorney that this document was filed. And so now you've accomplished 3 PMBR checklist items about making all of your information searchable, placing your documents in the proper folder structure, and notifying senior counsel about when things happen so that they can react to it. All of those are just technology steps that can be automated. And so if you can automate your PMBR checklist system, then that's one less thing that you have to monitor and you have to be careful of, and you have to continually train your staff on because the technology is doing it for you. So those are just 2 important aspects of where technology intersects. Now, yes, we are also concerned about things like confidentiality. I don't know if you remember Dropbox, for example, but Dropbox was a huge and popular application, but it didn't seem like it protected anybody's confidentiality because all the information went into one very large Dropbox, and it was arguably cross-indexed and cross-searchable and decompiled in its storage. And that didn't feel like that was protecting our clients' confidentiality. So certainly we have to consider those effects of technology as well. I think ChatGPT is one where people are concerned. If I ask too detailed of a prompt, if I mention an area of law or a company or a person or some very concrete facts in my engineered prompt, is ChatGPT learning something about my client that they should not otherwise know? And so we have to be cautious about how we're using technology like that. So the intersection of technology and PMBR is going to be an ongoing conversation, and one that's going to require a lot of diligence on my part as well as the part of law firms in order to protect our interests and the interests of our clients.
Sure. Yeah, the Chat GPT question. I feel like the jury is going to be out on that one for a while because I've heard a lot of different folks talk about how we should approach putting information into these models. And some firms say do not put anything at all into Chat GPT, and other firms have AI policies, and I think there's a safe way to do it. So unfortunately, I think this might be something that has to get litigated before we have an answer. But I certainly don't have the answer, so I will let the experts sort that out. But I did want to return to something that you mentioned earlier, because I think, we talk about being proactive as a generally good thing. It can save you a lot of heartburn down the road. But I can just hear, objections that, oh, this is just like another administrative burden. I don't have time for this. So I want to circle back to kind of another incentive that you talked about earlier, which was setting up PMBR can actually help you later down the road if something does go wrong and you're in front of the bar, how it could be or is in some states a mitigating factor. So can you talk about that, how PMBR is good on the proactive side, but also on the reactive side if you do find yourself in a dispute in front of the bar on the other end of a bar complaint?
Well, among other opportunities I've had the opportunity to work with bar counsel, and I've actually set up databases to collect complaint information about attorneys and help the bar process those complaints using software like practice management software. So I've seen a lot of data, actual physical data of complaints against lawyers in systems. And so what I've learned from seeing how the bar has responded to these complaints is that I find them to be really quite reasonable. And they're not punitive because they want to be punitive. If they're punitive, it's because the attorney is unresponsive. If an attorney is responsive, if you say, I thought there might be a problem in this area, and so I did increase supervision of this staff person, and I did look up on the webpage what a PMBR checklist might look like for supervising staff, and I implemented those things. However, I didn't catch it soon enough, and that employee embezzled my funds. I'm responsible. I was supposed to supervise. I didn't do a good enough job. Now, what do you think the bar is going to do with a response like that? They're going to accept that as a reasonable response. And they're going to say, okay, well, this is pretty serious. Yes, you're going to do retribution or compensation. You're going to inform all of your clients that they have an opportunity to get their money back through our client protection program. You're going to fall on your sword in the following ways. However, instead of a public reprimand, we're going to do a private reprimand to protect your reputation because you demonstrated a responsive and thoughtful answer to this complaint. So it's not just that you did PMBR, it's that you cared about it and you engaged and you wanted to do a better job and you thought you might have supervised better. So while you are not going to find any state who will say in writing, if you do PMBR, we'll go easy on you, you're not going to find that. That's not in the culture to respond that way. Their job is to protect the public. And they're going to say, we're going to protect the public. We hope that you will also help us to protect the public. And if you demonstrate a willingness to do that, then it will be a mitigating factor. So that's really where that lies. I haven't been to all these web pages and read the preambles and looked at all the information. And no one is saying that it is actually like a formal mitigating factor right now.
Okay, that's good to know. Yeah, I think that is a common misconception in law schools, and maybe as an associate, you're taught to avoid the bar at all costs, which is probably a good rule of thumb. But I think it's seen as like this boogeyman entity that is out to get attorneys and is like lurking around every corner and just waiting for you to mess up, and then they're going to come down really hard on you. But I have a friend who's actually a lawyer for lawyers who are facing bar complaints, and yeah, very, very similar sentiments that the bar is willing to work with you, right? Like their interest is not just throwing the book at attorneys. Their interest is protecting the public, making sure that you understood this thing went wrong and it doesn't happen again. And so I think that is a very common misconception in the industry. Yeah. So we always like to give listeners some practical steps, some sort of immediate takeaways that they can take away from this episode. So if an attorney is interested in implementing this type of framework for their practice, what can they do immediately to get started?
Great. Well, obviously, if they've listened to this podcast, they're already a lot on their way to implementing PMBR, because the first thing about it is that it's a self-assessment. And if you're willing to look inward and look at your own firm and not wait for someone to complain about it, you're really moving in the right direction. And so that's what we want to encourage, is the autonomy and the agency to make your own improvements. And if you're not the managing partner, you're one of many lawyers within an organization. That doesn't mean you can't do your own PMBR. You can look at how you do things and how your particular staff, the people that you supervise, how they do things. And you can have meetings and talk about how you want to do things better. And you can bring up these checklists and just go over them out loud with people, and that will change behavior. What we measure gets changed. And so if you measure responsiveness, if you measure confidentiality, if you give your staff a chance to even grade themselves and say, on a scale to 1 to 10, how responsive are we as a firm? How do they feel? Do they get a lot of complaints? Do they get few complaints? Do they feel like they respond in a timely manner? That makes a difference, how they perceive themselves. So that's the first thing, is to learn more, is to download some of these checklists and try them out. And then third, of course, you can hire a consultant to come in and spend time and lead people through the conversation. Sometimes that's really helpful to have an outside personality be the one advocating for change within a culture. And then they leave and everyone can consider the source and not take issue with the material. And that's really what you want, is you want people to embrace the material and to move forward with confidence, to better represent clients and to better protect the interests of the public, as well as protect the long-term objectives of the firm.
Well, David, thank you so much for being here. Where can listeners find you, and what is the best way for them to learn more about you and your work?
So thank you for having me. It's been a delight to talk about this subject, something I've spent a lot of time with over my years working as a software implementer. Think about how the software can better serve the law firms. And now that we have PMBR, we actually have a framework for that intersection between technology and the checklist system. I'm a member of the Crosspoint Consulting Group. You can find us online. We have recently completed 10 separate blog posts on PMBR, and we're going to publish tomorrow, which is going to be Thursday, June 26th, kind of a summary statement tying together all the different blog posts about PMBR together in one final blog post. We also hope to be talking about the PMBR at the ABA Tech Show coming up next year. So I hope you'll join us for this conversation. And if we could help you or your firm implementing software or developing policies or procedures that better align with your goals, it'd be our pleasure to do so. Again, I'm David Michael, and that's dm@michaelmatters.com.
Okay, perfect. Thank you so much again, David.
Thank you. It's nice spending some time with you, Lauren.
Thank you all for listening. We'll catch you on the next episode.
And join us again for another Rule of Law podcast from All Rise.